Welcome to the Jeff Rude Real Estate Channel. On this channel, I share insights and opinions about my three professional pursuits: real estate law, real estate sales, and virtual real estate. This is my first real estate law video. It is inspired by a very funny movie called Bridesmaids starring Kristen Wiig. It has heart, it has potty humor. I'm talking about the movie, not this video. Anyway, in Bridesmaids, Kristen Wiig is a struggling but likable ne'er-do-well, that's the word, right? Ne'er-do-well single bridesmaid who is a talented baker, but unfortunately the bakery failed, yada yada yada, she's down on her luck, and there's a scene where she's inspired to get back into baking again, and I thought that leads us to a good example for this video. Prompt for us to discuss, which is what documents are required for Kristen Wiig to get a loan, buy a building, and start her bakery. The bank, being the one with the money, is going to call the shots, at least in the beginning of the negotiations, and lay out all the financial terms. Then once the bank is comfortable with the borrower and the collateral, it will provide documents for Kristen Wiig to sign, but most likely only a few days to review them, and there'll be hundreds of pages altogether. You could bet these documents will be as pro-bank as possible, up to and even beyond what the law requires. The document will probably have a clause saying, to the extent any of these provisions are unenforceable under law, whether due to being unconscionable or statutorily prohibited, all other provisions will remain in full force in effect. So if you see that clause, don't be too scared. That's sort of standard language. So what Kristen Wiig probably should do is consider requesting all the documents, all the loan documents, as soon as possible, even before her loan is approved. These are normally form documents that the bank will then customize for the loan. So she should request them as soon as possible so she could read all of them, and if there's something she doesn't understand or thinks is unfair, she could bring that document or that specific question to a lawyer, and rather than giving it to the lawyer and saying, hey, does this all look good? And that would save a lot on legal bills, especially if the lawyer charges by the hour, because these bank loan documents will be huge, especially if they're SBA related loans, meaning Small Business Administration, because there's going to be all sorts of government government required language, because the government's participating in the loan. So as promised, I'm going to list and briefly describe the key documents in the loan. But first, before I list the documents, I want to talk about the overarching tension between the borrower and a lender. This is in any real property transaction that involves a loan. The qua break. The borrower generally wants the biggest loan it could get with the lowest interest, the most flexibility to modify the property and operate the business. The borrower wants to be able to take out other loans for the business. The borrower should keep that in mind. Sometimes they don't, but the borrower should want to be able to take out other loans for the business, and the borrower should try their best to not be personally liable to repay the loan. Put it in the name of the business. The lender generally wants the opposite of all those things. It wants the loan to be no more than 80% of the purchase price for the property. The lender wants to charge a high interest rate, wants to include a prepayment penalty in case the borrower finds a better lender to refinance with. The borrower wants to be able to, or the lender wants to be able to hold the borrower personally liable to repay the debts, and to prohibit the borrower from taking out other loans, so the lender doesn't get in the scenario where it has to fight with other creditors over who gets paid back first. Also, the bank, in case it is going to foreclose and then have REO, real estate owned property. The bank's going to prohibit in the loan documents activity that could damage the property. So, for example, everything has to be built with all of the required permits. And Kristen Wiig, for example, she can't improvise building a brick oven or a walk-in fridge. You gotta do it by the books. So those are things that the bank will want. So, what are the main loan documents? There's others. These are the main ones, and that's all I'm going to cover here. You got the loan agreement, the promissory note, a personal guarantee, a mortgage, in Florida I'm talking, or all lien theory states, a mortgage, a state financing statement, also known as like a UCC1, and a closing statement. Loan agreement, promissory note, personal guarantee, mortgage, state financing statement, and the closing statement. 1. The loan agreement. The loan agreement is the most comprehensive document and sets out the major terms of the loan that the parties must follow. It is not recorded in the official records of the county. The other loan documents that I mentioned and the ancillary ones, smaller disclosures or affidavits, they'll incorporate the terms of the loan agreement, meaning all terms and conditions of the loan agreement are part of this document, so they don't have to restate it all in those documents. They're able to keep them short. Borrower's failure to follow a term in the loan agreement will be a default of the entire loan, not just of the loan agreement. The loan agreement will provide what are called notice and cure rights, which set out the time the borrower has to rectify a violation of the loan agreement. And then it will set out the remedies available to the lender if the borrower does not timely cure the violation. Notice and cure. Notice the borrower of the default, that the borrower has time to cure it. 2. The promissory note. A promissory note's a written promise to pay a certain amount to the lender at a certain date, or on demand if there's a loan default and the lender's able to accelerate the entire balance. Promissory notes get litigated a lot. There's very specific requirements in them. They lay out the interest rate and how it could be recalculated. A lender's wise, in my opinion, to keep the promissory note to the bare essentials under the law and instead put as many terms as possible into the loan agreement. The promissory note is one of those documents that's an original copy the bank will keep. Is very important to the bank to have the original. 3. The personal guarantee. Businesses prefer to enter loans and contracts in the name of their business rather than individually. Any lawyer will advise you of that 99% of the time. This way, only the business assets are on the hook if the business breaches the contract. But if you're new to the business, or you have only a few assets, or your assets are already encumbered by another bank, the bank's going to make you sign a personal guarantee. And what that means is upon a default of the loan agreement, whether it's failure to make your timely payments or a non-monetary default, which would be like violating a local ordinance, the signatory of the personal guarantee can be sued even before the bank sues the business and can liquidate the signatory's assets and even foreclose on your home, depending on your homestead protections in Florida. So Kristen Wiig and Bridesmaids, with a brand new business and no assets, she'll not only have to sign a personal guarantee, but the bank, to approve the loan, may also want her to get someone else, like her Maya Rudolph, her newly wealthy friend in the movie. They'll try to get her to sign a business guarantee as well, or the bank will say, Kristen, you need a business partner to guarantee the business as well. So she'll say, Maya Rudolph, come on, be part of the bakery. Also, if you're married, they're going to ask your spouse to sign the personal guarantee. And that would be enforceable even if you divorce. Yeah. 4, mortgage. You've heard of a mortgage. The mortgage covers a lot of the same items as the loan agreement and the promissory note. The important feature of a mortgage is it's needed for the lender in Florida to have a valid foreclosable lien on the real property, as far as being higher in priority than other creditors. The mortgage secures the loan, so often the mortgage will be called, the title of the document will be called Mortgage and Security Agreement. Like the deed, it is recorded in the official records of the county in which the real property is located. I think I mentioned before, Florida is a lien theory state, whereas other theories are title theory states. The documents can be a little different in those states, and the law is different. But in those states, like Georgia, for instance, they'll use what's called a deed of trust rather than a mortgage. You still get a deed, and then the mortgage document is called a deed of trust. 5, the state UCC-1 financing statement. This is a 1 or 2 page document on an official form and submitted to the Florida Secured Transactions Registry, which is a publicly searchable registry like the county official records. In this case, the mortgage does not secure non-real property assets. You need a state UCC-1 financing statement to help secure and perfect, is what it's called, your personal property. That would be things like your bank accounts, your intellectual property, your accounts receivable. So that would be very important to a bank. And you don't sign, the borrower doesn't sign that document, but in the loan agreement and other documents, the lender will have permission to file that document. 6, the closing statement. The closing statement, also called the settlement statement, is an itemized list of fees and credits summarizing who is paying what to whom as part of the entire real estate transaction. I'm going like this because normally it's separated into like 2 columns. So for example, it'll show who pays the various taxes owed to the state on the loan, and it makes it clear, should make it clear how much the borrower needs to bring to closing and how much loan proceeds will come from the bank after deducting costs, and how much the seller will walk away with after it pays its lender off. It's nice when the 3 parties, the seller, the buyer/borrower, and the lender, use one consolidated settlement statement. Speaking of the seller, the loan documents are only half of the deal. The other half is the purchase and sale, which has its own documents. These are between the seller of the building and the buyer/borrower. The buyer/borrower, that person and their lawyer, they're busy because they're dealing with the purchase and sale and the loan agreement, the loan documents. So the bank is very interested in these documents, the purchase and sale documents, because the bank's collateral, the property, is dependent on what was actually sold by the seller to the borrower, to the bank. And that could only be determined by reviewing the key purchase and sale documents. A good bank lender will want to review those documents. So the main purchase and sale documents are the purchase and sale agreement, often called the PSA, the deed, a general assignment, and a title insurance policy, which is not technically a purchase and sale document, but it's relevant to all this and very important. 1, the purchase and sale agreement is often called the PSA or the APA, the Asset Purchase Agreement. It sets out the rights and obligations of the buyer and the seller. It includes things like the purchase price and the latest closing date possible. Buyer must close by X date. It sets out reps and warranties from the seller regarding the condition of the property, the rights for buyer to inspect the property, deposits that the buyer has to give, how long to take the property off the market. how long the buyer has to inspect the property before the deposit becomes non-refundable or hard money deposit, and conditions for the buyer to close, such as this deal is contingent on the buyer obtaining financing, and what the buyer has to do to satisfy, a best efforts to obtain financing. You can't just say, I didn't obtain financing, so let me out of this deal, but you didn't do any work to try to get financing. So the PSA is a roadmap to the entire sale process, kind of like the loan agreement for the loan. But the reps and warranties and other obligations in the PSA usually end after the property is conveyed, unless the PSA says otherwise. The loan agreement, continues indefinitely. And the day the PSA is executed and the closing date of the whole property, those are the two most exciting dates. And they're normally at least 30 days apart, sometimes up to 180 days apart. And parties can negotiate for extensions, and sometimes it'll cost the borrower some money to extend. 2, the deed. The deed is the document by which title to the property is transferred. It is recorded in the county official records. It states the identity of the seller, the buyer, the purchase price, the formal description of the property, also called the legal description, which is not a simple street address. And it often includes other real property related rights that are being conveyed, like easements. And it'll state if the title to the property is subject to all matters of record or subject to specific matters of record listed, which will often mirror the list that's in the title insurance policy, the exceptions to the title insurance policy, which I discuss later. 3, the general assignment. A formal assignment document is often overlooked, but buyers want real estate not just for the dirt and the physical building, but because they're trying to operate a business or build homes on the property or build and operate more businesses on the property. So those things require licenses and permits and development agreements from various governmental agencies that the seller worked hard to get. That forms the value of the property. And the value of the business is built up by the ability to use warranties and vendor contracts and advantageous maintenance contracts the seller had in place already for the building, like for a grease trap for a restaurant, a maintenance contract and warranties for the grease trap for a restaurant. So if the seller does not assign all those rights to the buyer and obtain consents from those third parties, that could impede the buyer's ability to accomplish its business plans. You really want an assignment document. From the bank's perspective, that assignment document's important for the bank to then be able to have an effective lien on the buyer's alleged rights in the property. 4, the title insurance policy. The title insurance policy is in favor of the buyer, often called an owner's policy, and simultaneously it's issued to the lender, called a lender's title insurance policy. Title insurance is hugely important in commercial real estate. Basically, a lender's title insurance policy is issued directly from the title insurance company or an agent of the title insurance company, which is often the seller's attorney. In Florida, there's a statutorily provided rate for how much title insurance costs based on the amount of insurance coverage that's purchased, which is normally around the purchase price, or for a lender, around the amount that the lender loans to the borrower. And it provides coverage to the lender for losses due to things like, most importantly, if the seller was not the actual owner of the property to begin with, but also disputes over liens on the property or rights of third parties to use the property via an easement. The policy will include a list of exceptions to the policy, which are specific things about the property that were discovered that won't be insured. For example, a known easement from a utility company saying that they have the right to add a power line over a certain portion of the property. If the title insurance company knows about this, they're going to list that document as an exception to the policy, and then the title insurance company will not compensate the owner or a lender for a loss of value to the property because the utility company decides to use those rights to build the power line. That's one example. So there you have it. I hope you find this useful or of some interest. I'm going to do a video about documentation formalities and tools like DocuSign, e-recording, remote online notarization. Do you need a wet signature? Is a copy okay? All that stuff's going to present a fuller picture of the actual process on the day of closing a deal like this Kristen Wiig from the movie Bridesmaids obtaining a loan to purchase a bakery. Until next time, please be kind to each other and yourself. Thank you for watching.